ever wondered what really happens when you issue shares to your co-founders or investors? The way you structure those shares can decide who controls your company, how profits are distributed, and even whether you face tax problems down the road. Hi, I'm Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is actually my AI avatar, presenting from a script that I've personally written and approved. Today, we're breaking down the key considerations when issuing shares in Australia, from choosing the right structure to drafting shareholder agreements to managing investor expectations. By the end, you'll understand how to protect your position, avoid disputes, and set up your startup for long-term success. Before you issue any shares, your company needs to be set up properly. In Australia, most startups register as a proprietary limited company. This structure is governed by the Corporations Act 2001 and gives you limited liability, the ability to issue shares, and a clear legal framework for investor participation. Next, you need to decide how to split equity between the founding team. This usually depends on each person's contribution, whether that's capital, intellectual property, time commitment, or domain expertise. It's also common to think about future roles and responsibilities. To protect the company if a founder leaves early, many startups use a vesting schedule. A typical schedule runs for 4 years with a 1-year cliff. That means if a founder leaves within the first year, they don't get any shares at all, and over the remaining vesting period, the shares are slowly earned. Again, if the founder leaves early, they are only permitted to keep the shares that have been earned. Startups often issue different classes of shares for different purposes. Ordinary shares are usually given to founders with full voting and dividend rights. Preference shares are usually given to investors, and these can include special protections like liquidation preferences, priority dividends, or anti-dilution clauses. It's essential to clearly define these share classes and rights in your constitution or shareholder agreement, so there's no confusion later. A shareholders agreement is critical. This is the document that sets out each shareholder's rights and obligations. It covers share transfers, dispute resolution, decision-making, board appointments, and exits. A well-drafted agreement reduces conflict and creates stability for the business. When you issue shares, you need to comply with ASIC requirements. That means lodging Form 484 to record shareholding changes, updating your share register, issuing share certificates, and keeping proper meeting minutes. If you raise more than $2 million or issue shares to more than 20 investors in a 12-month period, disclosure requirements may apply unless you qualify for an exemption, such as the sophisticated investor test. You are also generally prohibited from advertising the sale of shares in the public domain, unless exemptions apply. Valuation is another key consideration. Issuing shares at a discount or without proper valuation can create tax problems, especially when shares are issued to employees or related parties. The Income Tax Assessment Act sets out when share benefits may be taxable. One common tool for startups is the Employee Share Scheme, or ESS. These schemes allow you to issue equity incentives to staff, often with tax advantages, but they need to comply with strict rules, including valuation and reporting requirements. Every time you issue new shares, existing shareholders are diluted. That's why you should model future funding rounds and understand how they'll impact ownership and control. Some founders also use convertible notes or safes, simple agreements for future equity, to raise capital without immediate dilution. If you want to know more about safes and convertible notes, we have a separate video on that topic on our channel. Professional investors will often negotiate specific rights as part of their deal. These can include board seats, veto powers on key decisions, tag-along and drag-along rights, and reporting obligations. Balancing these rights is essential to keep investors confident while still retaining founder control. We also have a video detailing founder rights that you can find in our video library. Finally, think about the bigger picture. The way you structure shares today will affect your ability to raise capital, attract talent, and eventually exit, whether that's through a sale, a public listing, or long-term ownership. Equity decisions now shape your future funding, governance, and succession planning. Issuing shares isn't just a numbers game. It's a legal and strategic decision that impacts every aspect of your business. By understanding the regulatory framework, the tax implications, and the long-term consequences, you'll be better equipped to grow your company sustainably. For tailored advice on structuring equity, preparing shareholder agreements, and complying with ASIC requirements, contact Leo Lawyers. You'll find all our contact details in the description box, or you can visit us directly at leolawyers.com.au. Thanks for watching. See you next time.